Shuichi, just remember, I will stop sharing this welcome slide, and then you can start talking. I just leave it for a couple of seconds to get the people in. Okay, I'm opening the waiting room.
Yeah, probably we should get started now. Hi, this is Shoichi Okuyama, Vice President of AIPPI International, and we are very happy to introduce you to the new series of webinars entitled Scan the Globe. As a part of the 125th anniversary program of AIPPI, we plan to cover frontiers of intellectual property protection such as ASEAN, Africa, Middle East, Central America, and so on. This project will be made possible not by AIPPI alone, but in cooperation with governmental and other non-governmental organizations. This time, we are fortunate to have kind cooperation of the Singapore office of WIPO, specifically Peter Willimott, to whom we are very grateful. We are now preparing the next and subsequent programs in the Scan the Globe series, so stay tuned and enjoy this first installment. Yeah, there are a couple of housekeeping issues here, so I will just announce 4 points. The one is that during the presentation, please mute yourself. Question to the panelists can be submitted at the end of the presentations, at the very end of the presentation, all the presentations. Please raise your hands and using the reactions button. For the technical problems, please send a message in the chat box to AIPPI events. The slide used today will be available upon request at the events at AIPPI.org. Now I would like to introduce Peter Wilmot, who is leading today's presentation. He is officer in charge at WIPO. Mr. Wilmot is vastly experienced in the field of intellectual property, having worked for World Intellectual Property Organization, WIPO, and Australian IP office for combined years of 21. And at WIPO, he works closely with governments and businesses throughout the ASEAN regions to increase the awareness, understanding, and the use of WIPO's global IP systems such as PCT, Madrid, and Hague. He's a regular presenter at events and workshops in the region. The rest probably you can read from the available, well, the screen. And without much ado, I would like to give floor to Peter. Peter, please.
Thank you very much, Shuichi. It's a pleasure to be here with you all today. As Shuichi said, my name's Peter Willimott. I'm the officer in charge at WIPO's Singapore office. And from the Singapore office, we cover the ASEAN region. May I start by letting you know that WIPO is very pleased to be involved in this useful AIPPI initiative as part of celebrations in relation to AIPPI's 125th anniversary. WIPO and AIPPI have a long history of collaboration, and I look forward to this continuing. I'd like to express my thanks to the AIPPI, in particular Secretary General, Ms. Annie Tsoi, for involving WIPO in this webinar, and to Shoichi for his opening remarks. So first up, if we just have a quick look at the agenda that we're going to run through today. It's been put together to try and give you a flavour of what's happening in the ASEAN region from an IP perspective. So we're going to start with an outline of the IP systems in Southeast Asia, followed by an overview of applicable treaties and the sort of trends in IP usage within each ASEAN country. Followed by that, we'll dive a little bit into expected changes in the IP system and legislative updates across the region that will be covered by some expert speakers. We'll then have a question and answer session before closing at about 11:30 in European time. Let me just say some very brief opening remarks before I pass the floor to our first speaker. And after living and working in ASEAN for the past 10 years, personally, I think ASEAN can be characterized as having incredible diversity, cultural richness, and potential. Now, the diversity is in virtually every facet of each society, and this diversity is in the level of development of member states within the region, to the key industries of each country, even the modes of government, language, and culture. So it's very hard to implement a one-size-fits-all policy for the region. And as the ASEAN Secretariat highlights, ASEAN's diversity is reflected in the colourful lives of its people. ASEAN is powered by more than 600 million people, most of whom are young. More than a quarter belong in the 15 to 29-year-old bracket, while around 10% are children aged 5 years and below. Only 6% are seniors or 65 years old and above. As a result, when working in ASEAN, one must take a tailored approach to address each country's unique needs and circumstances due to this diversity. Now, I mentioned cultural richness. The region's cultures have been shaped over time through influences such as Indian, Chinese, Portuguese, Spanish, British, Russian, American, Indigenous, Malay, making it a fascinating mixing pot, a fascinating part of the world. That needs to be considered when you're working in ASEAN. Lastly, let me touch on potential. As I mentioned, ASEAN has a young population with many emerging economies, and these attributes contribute to this sense of potential. But just saying ASEAN has potential does not recognize that today some potential is already being realized. One only has to look at the economic growth achieved over the past 2 decades to see progress. Yet I think it's still realistic to say that many ASEAN member states have a great deal of potential to innovate, to create, and to generate significant sustainable economic growth. So for our audience today, I guess the key question is, how can I unlock this potential for my clients? Well, of course, the answer will involve IP. So the program today has been developed to share with you a snapshot of the region and how different countries are using or employing the IP system, as well as giving you some information on the latest developments and updates to IP laws and practices at the national level. And with that, let me introduce our first speaker, Mr. Elio de Tullio. Elio is an Italian lawyer and an external expert at the Southeast Asia IP SME Helpdesk. And I'd like to especially thank Elio for joining us today, because today is a public holiday in Italy for Republic Day. So while the rest of Italy is out celebrating Republic Day, Elio has been kind or crazy enough to come and speak with us and give us some of his valuable time. So just a little bit about Elio. He's an Italian lawyer admitted at the bar of Bari and trademark attorney. After 10 years of experience in IP matters, he founded the law firm, the Tullio and Partners, with offices in Rome and Bari, and a liaison office in New York. And as the managing partner, he acts as a trademark attorney in the strategic assessment of IP protection and in prosecution and opposition processes at domestic and international level. He's also a litigation lawyer before the Italian courts, specialized in IP, specializing in trademark design and patent issues. I'll skip to the next point. And since 2014, he's acted as a speaker at numerous webinars and training events on the protection of IPR in Southeast Asian countries, which is very much why he's speaking today as one of our experts. And furthermore, he's also written some articles on Italian and European law on IP rights, which have been translated into Chinese and Southeast Asian languages. So, Elio, the floor is now yours, but I believe we're going to hear a quick video outlining the work of the Southeast Asia IP SME Help Desk.
So thank you, Peter. I just share my screen now and start my presentation. So thank you for sharing the video. This was about the services of the EU Southeast Asia IPR SME Helpdesk. That can be summarized also in this slide. So I underline the fact that all these services are free of charge. We have an inquiry helpline, so you can receive an answer on any IP related issue in 3 working days, and a lot of materials on the website, like guides, fact sheets, newsletter, and of course there are some also e-learning modules that you can use for the knowledge of IP in Southeast Asia. Some introductory consideration. You said that there is no fit for all IP instruction for any country of Southeast Asia. So it is better to have a radial, let's say, approach. So strategy that can start from the place in which you take the decision, where there is the head of your research and development strategy, or your marketing and communication division. So it is crucial to identify an EU IP attorney as representative that can liaise with the local representative or agents for operative activities in the country of destination. Usually in some Southeast Asian countries, application can be filed by foreign companies if they have an address for service in the country, or by appointing a local agent. This is the case of Cambodia, Laos, Malaysia, Thailand, Indonesia, Vietnam, and the Philippines. And the power of attorney is usually needed. Sometimes a simple POA is sufficient. In other cases, the POA should be notarized and legalized. It is important to stress that an approach considering the interdependence of IP rights is very advisable. Indeed, you can use, for instance, copyright as background rights in case the other rights are not so clear, and so it's always good to use different IP rights to protect your products and services. In this case, you will have multiple layers of protection for your products and different possibility of enforcement in different Southeast Asian countries. It is very important to carry out preliminary searches before filing any IP right, but we will go through this afterwards. In terms of trademarks, for instance, there is an evolving legislation and practice regarding non-conventional trademarks. Here you can see a table that is the usual table you can find on Southeast Asia AIPPI SME Helpdesk website, and it is there is the list of conventional and non-conventional trademarks that can be filed in different Southeast Asian countries. And for instance, you can see that Singapore accepts basically all non-conventional trademarks. What are the peculiarities of the trademark system? You have two ways of protecting your trademarks in Southeast Asian countries, the local part and the international part. The majority of countries are member of the model system administered by WIPO, with the exception of Myanmar, that is not member of the model system and is not member also of the Paris Convention. You can find a guide about the possibility to use the model system for protecting IP rights, for protecting your trademark in Southeast Asian countries, and on the link you can find in this slide. The majority of countries, with the exception of Myanmar, provide for a multiple class application system, so you can file an application claiming several classes with let's say the save of money. But Myanmar still requires separate trademark application for each class of goods or services. Please be reminded that Myanmar is just developing its trademark law, and until 2019 there was no trademark register in Myanmar. Indonesia, Thailand and Vietnam require the local application to be filed in their respective languages. Why to file an application and register your trademark in Southeast Asian countries? Because usually there are phenomena like trademark hijacking, so bad faith trademark application registration, and the resale of the trademark to the legitimate owner for abusing price. So in order to prevent this, it's usually very advisable to file and register your trademark, not only the Latin characters format, but also the local characters formats. So of course you need to first see if this local translation has a negative meaning in the country of destination, but after this you can carry out a search. You can carry out a search for your Latin or for your transliterated version of your trademark, and then file the application. So in this case, you will be able to prevent this hijacking phenomenon. Some countries adopt the first to file system, for which the first person or entity to register a trademark will be the right owner. And in these countries, it is good to seek protection of the trademark as soon as possible. Indeed, even the country that adopt the first-to-use system, this first-to-use system that protects, let's say, the de facto trademark only used in the market and not registered, is given according to some condition. First of all, the goodwill in the use of your trademark. So let's say that it is better always to file an application and register your trademark. Singapore adopts, let's say, a mixed system where non-registered trademark can still be protected through a low tort of passing off in case the trademark enjoys goodwill and reputation. In order to carry out preliminary search, you can use the ASEAN PMU, that is a free of charge online tool. You just can Google it and find it for a real first line approach to a trademark search. But the interpretation of these data is very important in order to assess the proper likelihood of confusion of the proposed trademark with confusing dissimilar trademarks. So the suggestion is to liaise with your IP attorney in order to be supported in the interpretation of these data. Going to patent protection, according to the majority of the Southeast Asia legislation, the legal requirements are not so different from those valid in, for instance, in EU member states or adopted at the European Patent Office level. So novelty, non-obviousness, the so-called inventive step, and industrial applicability. There is a peculiarity in Cambodia because pharmaceutical products are excluded from patent protection until 2033, as Cambodia currently benefits from the WIPO, from the WTO waiver as a least developed country. You have the possibility to protect even small inventions. So those inventions that have a lower degree of inventive step, they have different names in different countries. In some countries are called simple patent or petit patent or utility innovation. The characteristic is that the duration of the protection is shorter usually. And of course, they have another value because they are not submitted to substantial examination by local IP offices. As to copyright protection, although registration is not required in terms of territorial protection, copyright registration is very helpful in proving ownership in case of enforcement action, because it is a matter of reverse the burden of proof. And the authority usually, so for instance, courts rely on copyright registration as evidence of ownership before accepting the case. So in this case of copyright filing, the fees, official fees, are very low. And once again, I strongly recommend to file a copyright application. Even for industrial design, you have the possibility to protect the aesthetic part of products, provided that this aesthetic part is new, original, and have individual character. The duration of the design rights lasts for 5 years with renewals different from country to country, up to 15 or 25 years. In some countries like Malaysia and Singapore, products cannot be simultaneously protected by copyright and registered industrial design, but in other countries this is possible. A product can also enjoy the protection of the aesthetic part as 3D trademark, of course, provided that it has a distinctive character. In some countries, the novelty can be lost if there is a public disclosure of the design before the registration, but in some other, there is a grace period, 6 months, for instance, for Philippines and Indonesia, and 12 months for Cambodia, during which the applicant's own public disclosure will not invalidate an industrial design registration. And finally, trade secrets. Trade secrets in Southeast Asian country is protected if it is not generally known to the public, so it has been kept as confidential. It confers economic benefits on its holder. It is subject of reasonable efforts, let's say reasonable measures, technical, physical, or legal measures to keep the information secret. And if the information has been kept secret, so it can be protected even before the court. Here you can see different way in which trade secrets can be protected in different Southeast Asian countries. And of course, keep this slide in mind in case you would like to protect your trade secret. And finally, 3 slides about tips and tricks for SMEs and startups in order to prevent problems in Southeast Asian countries. For instance, an upgrade of your non-disclosure agreement can be an NNN agreement, non-disclosure, non-use, and non-circumvention. So in these agreements, the partner, the local partner, will undertake in written not to use your works in a competitive way, and for instance, not to circumvent the agreement and not to interfere with your clients about some important confidential information. Of course, the possibility to have these agreements enforced before a court are submitted to some conditions. For instance, the governing law of the agreement should be the national law, and also the competent court should be a local court. And finally, some key recommendations. So start protecting your IPR before entering the market. Prepare a strategy to develop your IPR protection, carry out the preliminary research first, take care of your first filing, protect the transliteration of your trademark, collect all the documents and keep them in order, monitor markets and competitors' behaviors, activate a worldwide surveillance system, monitor IP gazettes and legal actions, verify the compliance of contracts providing the local legislation as applicable law in order to understand the consequences of this provision, secure the ownership of your copyright through a voluntary filing, and check the local law carefully and pay attention to the public patent disclosure in order not to destroy novelty. Thank you very much.
Great. Thanks, Elio. I think that set the scene nicely. It's a big task to sort of give an overview of IP, IP environment across Southeast Asia in 10, 15 minutes, but you've done a great job. So thank you very much for that. Next up on the agenda is me. So we've heard about the IP systems, an overview of the IP systems. We're now going to, if you'll bear with me, I'll share my screen, explore a little bit about how the IP systems are being used in each country. And let me share with you, as I put together my presentation of statistics and data, it was slide after slide of tables and numbers. And I thought, gosh, this is very dry and lacking a bit of color and interest. And it needed spicing up. So I thought about how could I spice this fairly dry presentation up on ASEAN use of IP systems. And what I came up with is something that is common amongst all ASEAN countries, and that is a, just advance my slides, a love of food. Every ASEAN country loves food. So what I thought I would do is intersperse each slide with statistics with a slide on the national dish of each of the 10 countries in ASEAN. So first up is Brunei, and a typical dish in Brunei is something called amboyat tempoyak. It comes from within the trunk of the sago palm, eaten using a bamboo fork, where you dip the amboyat in different sauces, such as tempoyak sauce. And I have not had the pleasure of trying this, but next time I'm in Brunei, I hope to. So let's start after we've had our appetites wet with that dish from Brunei. I thought I'd just give you a very quick snapshot of ASEAN from a non-IP perspective, just in terms of population, GDP, and the main industries of each member state. Again, I'm doing this to sort of highlight the great diversity in ASEAN. So we have huge range of populations. Brunei, around 437,000, up to Indonesia, over 273 million, and everything in between. So small states like Singapore and Laos, PDR, and then larger entities in terms of population, Philippines, Thailand, Vietnam. And of course, reflective of Indonesia's large population is their larger GDP, over $1 trillion. But again, a lot of diversity, some representing or reflecting the size of the population, others reflecting the state of development of that particular country. And then the main industries. So lots of different industries in different ASEAN countries. So there's a sort of a thread of agriculture running through it. Some looking at textiles, the creation of electronics. Singapore, of course, specializing in financial services, and there's some chemical industry there as well. So just giving you an overview of what we're really dealing with in ASEAN. Okay, so next dish is Cambodia, a mok tray. It's a steamed or curried fish cooked in a cup made of a banana leaf with vegetables, ice, and coconut milk. It's very rich and creamy. It can be quite spicy. It's delicious. Next slide on accessions to WIPO treaty. So I've put up the 4 main sort of user-based WIPO treaties, and as Elio highlighted, PCT and Madrid are well represented, or ASEAN is well represented in those 2 treaties, with all bar Myanmar being members of those treaties. Madrid has had some reasonably recent accessions, so Malaysia in 2019, Thailand and Indonesia 2017, which is about 5 years ago, but still relatively new members of Madrid. The Hague are less represented in ASEAN, but we did have the pleasure of welcoming Vietnam to the Hague system in 2019, and those stars represent possible accession in 1 to 2 years. So based on WIPO's feedback received from Waipo, those countries are very interested in acceding to the Hague Agreement. Now, the others are also, but from what we've ascertained, possible accession in 1 to 2 years. And then we've got 2 very fresh accessions to the Geneva Act of the Lisbon Treaty in Cambodia and Laos. And Cambodia's accession indeed makes Cambodia the first ASEAN member state to accede to all 4 of these treaties. After Cambodia, alphabetically, we moved to Indonesia. And Indonesia is famous for its Nasi Goreng. And this is a type of fried rice, often made with sweet, thick soy sauce called kecap, and garnished with acar, pickled cucumber, and carrots. Sometimes has shrimp in there as well, some chili, egg on top. Right, let's get down to the nitty-gritty IP usage statistics in ASEAN. So this reflects the filings by residents in 2020. Now, resident is defined as an application filed in the country by its own resident. And the red highlights the highest in class. So for trademarks, and this data refers to number of classes, not just applications. So we've got, again, a wide variety of use. So Indonesia, the DGIPR in Indonesia receives over 80,000 trademark or applications for 80,000 classes of trademark in 2020, filed by Indonesians. Now, interestingly, if you look at the next column, in Madrid, Singapore has by far the highest number of Madrid filings, and it's coming from a relatively low base. So what does this tell us? What can we infer from this data? Well, I guess we can infer that a few things. Singapore as a market is reasonably small. So Singaporean entities are looking to operate overseas, and to do so, they're embracing the concept of protecting their brand in countries outside of Singapore. Hence, there's a relatively high proportion of residents, Singaporean residents, using the Madrid system. And I guess this is where the word potential comes in. When you look at the sheer volume of trademark classes being filed in Indonesia, in Vietnam, Philippines, Thailand, and the relatively low numbers using Madrid, there could be a few reasons for this. It could be a lack of awareness of Madrid. Perhaps they are using Paris route, filing directly just with one or two other, filing in one or two other countries. Or it could be a reflection that, Vietnam, Thailand, Indonesia are significant markets in themselves. So maybe most SMEs or brand owners are focused on making their business work nationally, and may at this stage not be as focused on expanding overseas. If we move now to patent and PCT, quite similar trend in that Singapore, although in this instance, Singaporean residents filed the most patents in 2020 and the most PCT applications. So that's a very high transition rate. So essentially, Singaporean patent filers are also filing PCT applications. And there's quite a high percentage of Malaysian patent filers who then are entering PCT, and Thailand also. If we look at design, it's slightly different in that we have Thailand. In Thailand, Thais are filing the most industrial design applications, or filed the most industrial design applications in 2020. So that perhaps reflects Thailand's creative culture, strong design community, and an appreciation of the way things look. Singapore topping the Hague use out of the member states who have acceded to the Hague. If we now look at the typical dish of Laos, it's larb. It's a very spicy mixture of marinated meat or fish, sometimes raw like ceviche, and has a variable combination of herbs, greens, and spices. It's a very fresh, rich, refreshing dish. You get that in Vientiane. So if we now look at AIPPI filings, and this is a combination of resident and abroad category for selected member states. So I've chosen 6 ASEAN member states here, noting the definition of abroad, and that is an application filed by this country's resident at a foreign office. And I've really taken 2016 data, comparing it to 2020 data to get a change percentage to see whether there's been a growth and how much growth over the 5-year period. So for patents, we see strong growth in Indonesia, in the Philippines, in Singapore, and Vietnam with a massive 79% increase on 2016 to 2020. Thailand and Malaysia had negative growth, but when I looked at the 2019 patent filings, they would have been positive. So I think this may be a reflection of the impact of COVID-19 on those 2 economies. Because not only did the filings fall, but I've got here in a footnote that GDP fell in Malaysia in 2020 for the first time in a decade, and similar story in Thailand, that GDP fell in 2020 for the first time in at least 10 years. So in a way, those patent filings reflect that. Not, of course, there's always a lag between when something is patented and when the investment in that R&D may have taken place. But we can only look at the data as it sits at the moment. When we move to trademark and looking at the same comparison between filing figures of residents and those residents who are then filing in offices abroad, we can see Indonesia had a significant change of 66% increase. Malaysia, as I mentioned, a slight dip. Philippines, a big increase. Singapore, a big increase. And Vietnam, a big increase. And again, the GDP over the past 5 years, when I compare 2016 GDP to 2020, all are experiencing growth. So in a way, the increase in filings is perhaps reflective of the growth in GDP, in indicating confidence in the economy, a very active economy that's in growth mode, particularly in Indonesia, Vietnam. So I'll leave that slide there. Our next dish is Malaysia, nasi lemak, a very delicious meal. It's fragrant rice cooked in coconut milk and pandan leaf. And then you have maybe some chicken, some nuts, some sambal, which is a hot chili paste, egg, some cucumber, and small deep fried fish to add a little bit of crunch and texture. So the next area of comparison I thought I would touch upon is related to the Global Innovation Index. For those of you not aware, the Global Innovation Index is one of WIPO's flagship publications. The GII helps countries assess their innovation performance and make informed policy decisions. So it's a tool for member states. It gets its publicity because it's a ranking of countries and their innovation performance. That's sort of what the media picks up on. But really, WIPO produced this 4 member states to look at the 81 different indicators that WIPO use to assess innovation, to really tailor or amend policies and initiatives to help increase innovation within their country. And often, many countries, I know in Vietnam, for example, they have a cross-ministerial task force that looks at the GII, and they may assign different projects to work on based on different GII indicators. So we're going to delve a little bit more into the GII, but before I do, here's Myanmar. It's mohinga, a rice noodle and fish soup. So this is how ASEAN performs in the 2021 GII. So we had 4 ASEAN economies ranked in the top 50. And of those 4, Vietnam improved a lot in the decade since 2011. Thailand went up a few places. Now, you know, you may look at Singapore and Malaysia and say, oh, they've dropped 5 spots each in those 10 years. They're not doing so well. I don't think that is accurate at all. I think Singapore is doing incredibly well to be in the top 10. And, you know, a drop of 5 spots is nothing really reflective of the innovation system in Singapore. Rather, it may be just a slight change in the way the innovation data is received. Some countries may have enhanced a little bit to increase their rankings. Same with Malaysia. But when you look at, say, the Philippines, that's a massive jump of 40 spots. So that is significant in its rise, as is Vietnam's jump of 7. Others, you know, we have Indonesia improving also significantly, 12 spots, and Laos also showing a little bit of improvement. The Laos and Myanmar are new to the survey, so I couldn't compare previous performances. Now, if we look at the Philippines dish, I don't know about anyone, if anyone's had any adobo, but it's a very meat-based dish. It consists of pork or chicken, or even sometimes both, and it can be stewed or braised in a sauce, usually made from vinegar, cooking oil, garlic, bay leaf, peppercorns, and soy sauce. And it's actually quite a hearty meal, served often with rice and steamed vegetables. Okay, I've put this in here because the rankings are in the GII are one thing, but how, you know, it's quite unrealistic to compare the GII performance of a developed country versus a least developed country. So this really tries to highlight whether a country is innovating at its level of development. So really, in this case, countries want to be either on the line or above the line. So we see here, Singapore is highlighted as an innovation leader. Thailand, Vietnam, and Philippines are performing above expectations for their level of development. Malaysia is performing, as is Indonesia, Cambodia, performing at expectations for their level of development. Malaysia is nearly going to be ranked as above expectations. I think if it continues to move further away from that line. Then we have Myanmar, Laos, and Brunei, which are at the moment performing below expectations in terms of innovation input and innovation output for their level of development. And speaking of, I just mentioned Singapore's innovation performance. In Singapore, a typical dish is chicken rice. And this is roasted or steamed chicken served over a bed of rice cooked in chicken stock. And there's some concern locally at the moment because there is a shortage of chicken. And the chicken rice sellers in Singapore hawker centres insist on using fresh chicken rather than frozen. That's what gives it a unique flavour. So chicken rice could be, well, it's quite scarce in the next few days and weeks in Singapore. Now, within ASEAN, we can look at overall strengths. So I'm not going to spend too much time on this, but 7 ASEAN countries were strong in creative goods. So I don't think that's surprising because, as I mentioned, there's a rich culture, a rich history of creativity within the region. So 7 ASEAN countries strong in creative goods. 6 are strong in high-tech exports, but you can see there, for example, Brunei is a strength in graduates in science and engineering. Cambodia has a strength in the criteria domestic credit provided to the private sector as a percentage of GDP. Indonesia, creative good exports as a percentage of total trade is a strength. Laos has a number of strengths. Now, this is in relation to its development. So again, graduates in science and engineering as Malaysia's strength. So the GII is a very rich data source. So if you're in the audience and you're interested in establishing a business in ASEAN, you might look at this and see which ASEAN country may be best suited to what you're seeking to achieve, or what services or resources you're trying to draw upon. Singapore there, political and operational stability is its very significant strength for Singapore. We're getting to the end of our dishes, and of course the typical dish of Thailand, pad thai. It's a stir-fried rice noodle dish commonly served as a street food, but also at restaurants. So it can be very quick and easy, or it can be served in very high-class establishments. Now, initially I did deem these food pictures national dish of country in question, but I know food is quite a passion. So if I said the national dish, for example, of Singapore is chicken rice, I may get in trouble if there are any Singaporeans in the audience, because some may say, no, laksa is our national dish or another thing. So typical dishes. Now, of course, ASEAN strengths, there are opportunities. These are areas where the score of this particular indice did not, was ranked as low or weakness. So every country has areas where they could improve. It could be something to do with the cost of redundancy dismissal, for example, in Indonesia, Malaysia, Philippines, and Thailand, or the ease of starting a business. So how much red tape is involved? Ranked lowly in Cambodia, Malaysia, and the Philippines. And final dish of the day, the pho. It's in Vietnam, a noodle soup eaten at any time of the day, but primarily at breakfast. So with that, I will leave my summation of ASEAN usage of IP systems and trends in innovation there. If you ever would like to get in contact with the Singapore office, I'll leave you my email address there. So thank you very much for your attention. And it's now my great pleasure to pass the floor back to Elio, who's going to run through a little bit of recent or expected changes in the IP systems within ASEAN. Elio, well, back to you.
Thank you again, Peter. Now I'm getting hungry because with all these dishes, I would like to try all of them. I will share my screen again. And we are going to talk a little bit about recent or expected changes in the IP system of Southeast Asian countries. First of all, I would like to mention that I will speak about GIs. That is different from the GII. GIs are geographic indication, probably you already know that. And in this area of geographic indication, there will be a lot of changes, or there has been already some changes in the national legislation and practice in Southeast Asian countries. But let's try from small operative tips. For instance, in Thailand, the government has temporarily exempted surcharges for trademark renewal fees during the grace period and surcharges for late annuity fees for patents, petty patents, and designs. These measures will be active until 30 September 2022 due to the emergency coming from COVID-19 cases in recent months, and the reduction of late payment will be up to 20% official fee surcharge for trademark renewals and up to 30% official fee surcharge for patents, design annuities for the late filing. In Thailand also, the copyright law currently in effect was submitted to some amendments, starting from 2015, then another amendment in 2019, and now the new recent amendment that will become effective on August 2022 in order to comply with the World Intellectual Property Organization Copyright Treaty and update practices in combating online infringements. The main change is in connection with the extension of the term of protection for photographic works, so the author's lifetime plus an additional 50 years after the author's death, and before was 50 years from the work's creation. In Philippines, as mentioned before, there is a new draft of the sui generis law on GIs. As you can see from the draft law provisions, this is, let's say, takes inspiration from the EU approach, the sui generis system. Indeed, there is also the protection of GIs against evocation. If you see at number 3 or number 4, the wines and spirits on one side, and agricultural products on the other side are protected also against translation or expressions such as kind, type, style, imitation, method. That is part of the evolving jurisprudence of the European Court of Justice. But in any case, Southeast Asian countries are developing their GI protection in different ways. Some countries are adopting the sui generis system, some others the trademark system. In Singapore, there are new amendments on registered design and geographical indication coming from the EU-Singapore Free Trade Agreement that came into force in 2019. Let's say that this phase 3 of the new amendments provides for the implementation of the obligations of strengthening enforcement measures at the border for IP rights, in particular designs and GIs, and implementing new powers in customs to obtain and provide information on sales of goods, and as well as standardized deadlines and provision for border enforcement in design and GIs. Next speaker, Regina Quek, will elaborate more about these new, let's say, legislative measures, even in connection with the simplified process that introduces a quicker and more cost-effective dispute resolution system in Singapore. In this case, claims are suitable under the simplified process if the dispute involves IP rights, the claimed monetary relief is not likely to exceed 500,000 Singapore dollars, and if, let's say, the complexity of the case is not so high. Some other amendments were introduced in Singapore by the AIPPI Amendment Act of 2022, and here you can see a list of key changes in the procedures and fees for filing patent application in Singapore, like an alternative form of office section, let's say a more informal way to resolve amendment in application, so without a written opinion from the examiner, or for instance, the publication of English translation of non-English international application that will be done automatically by the registrar. In Vietnam, on December 2021, the Ministry of Science issued a decree that took effect starting from January 2022, introducing some changes in the administrative sanctions in connection with the infringements of intellectual property rights. Also increasing the level of fines and providing more specific details on violation and remedies. And bear in mind also that Vietnam on April 2022 became party of the WIPO Performances and Phonograms Treaty, the WPPT, and implemented the agreement. This is regarding the rights of performance and producers of phonograms. In Malaysia, we can mention the Patent Amendment Act of 2022 that came into force on March 2022, and the key changes are related to the possibility to defer or modify substantive examination that is now available, the possibility for the registrar to file a request for re-examination of the amendment for a post-grant amendment, or other provisions regarding divisional application or the reinstatement of lapsed patent that has been shortened to 12 months. I will leave also this part to next speaker's elaboration, but let's mention that Malaysia has officially acceded to the Budapest Treaty and Marrakesh Treaty administered by WIPO, and that will enable the recognition of storage of microorganisms for the purpose of patent procedures. In Myanmar, we have a very special situation because, as mentioned before, there was no register for trademark, so the protection of trademark was achieved through the publication of the declaration of ownership on, let's say, magazines and newspapers. Now there is a new law, the new trademark law that was approved in 2019, and the new law divided the filing system into two phases, the soft opening and the grand opening. So the soft opening for the refiling of all registered trademarks under the declaration of ownership at Registry of Deeds, or the filing of unregistered marks previously under the declaration of ownership through the actual genuine use in Myanmar. And this phase of soft opening is still running, and so the grand opening now is postponed until further notification. So let's say that the situation is still in progress in Myanmar, but now for sure the situation is better than before. And in Indonesia, the government implemented the automatic recordation approval system for copyrights in order to higher the level of legal certainty, so increase the level of legal certainty and increase the confidence of copyright owners on voluntary registration. And in Cambodia, just a peculiarity that is not really a new law or a recent change. So since 2010, the European Patent Organization has signed a validation agreement with some non-member states, and one of them is Cambodia. So a European patent can be validated in Cambodia since the agreement entered into force in March 2018. And now Cambodia also became member of the Berne Convention starting from March 2022. And the final changes just listed in this slide. So the GI Bill in Malaysia that was passed by the House of Representatives, a new amendment about copyright law. In Thailand, the draft bill covering patents and industrial design, and in Vietnam, a draft IP law under examination is ongoing. This activity, the accession to the WIPO copyright treaty that was filed in November 2021, and the reduction of official fees. And finally, we don't have to forget the Regional Comprehensive Economic Partnership Agreement that entered into force on January 2022. That is a very big agreement of ASEAN countries with the major countries of the area like Australia, China, or Japan. So these are the partners of the IP Southeast Asia IPR SME Helpdesk. You can refer to all these website, well, the website of the Southeast Asia IPR Helpdesk mentioned before, And thank you for your attention.
Thank you very much, Elio. That set the scene again very nicely for our next speaker, because I know Regina Quek, second Deputy Secretary General at AIPPI, has spent a lot of time and effort in preparing her presentation, which will cover really some of those things you mentioned, but in a lot more detail. She's going to look at some of the legislative changes that are occurring within the region. So a little bit about Regina. She's the director and head of the IP practice at One Legal. She's instrumental in establishing AIPPI in Singapore and served as its founding president for 3 terms before stepping down to serve as a member of its executive committee. She served on a number of committees of AIPPI International, including the membership committee and the finance advisory committee. She is currently a member of the Bureau of AIPPI and currently serves as the 2nd Deputy Secretary General. So Regina, the floor is yours.
Thank you very much, Peter. Let me share my screen. Okay, I hope that's clear. Okay, thank you everybody. I'm very glad to be here this evening in Singapore. So let me go through this quickly. These are the legislative updates for ASEAN. First off, I'd like to acknowledge the collaborative efforts of the members of the AIPPI national groups who've helped me a great deal to put this presentation together. My grateful thanks go out to the members of national groups of Singapore, Malaysia, Philippines, Thailand, and Vietnam. So members of these national groups have also kindly made themselves available today for the Q&A session later. Thank you. So let me whiz through these changes fairly quickly. Some have been touched on already by Elio. So let's look at Singapore. I'm only looking at now the significant legislative updates. This is the Supreme Court of Judicature AIPPI rules of 2022. The purpose of these rules were to create a fast-track application process, which is called the Simplified Process. This is to limit the cost for litigants and also to shorten the timeline of the entire life cycle of a case, and also to increase the consistency in the procedure between the various IP acts, and to consolidate the procedural rules from all these different sources of law into one set of provisions that applies across the board. So let's look at the simplified process. This shortens the timeline for the life cycle. So all the guidance and directions are to be provided to the parties as far as possible within a single case conference. And the court is to give the directions as necessary for the case to proceed expeditiously, and as far as possible to direct that the trial to be completed within 2 days. And in terms of cost reduction, no cost issues to be made until the conclusion of the trial, and cost orders to be made only in respect of the items that are set out in the IP rules, and they're not to exceed the maximum amount stated therein. Total cost ordered against any party to be capped at 50,000 for an originating claim and 25,000 for a bifurcated assessment. Now, this does not apply to cost orders for unreasonable behavior. Now, eligibility. This process will apply to disputes where the dispute involves an intellectual property right, and where the total relief claim does not exceed $500,000 or all parties agree, and that the case is otherwise suitable. And this is having regard to whether the party can afford to bring or to defend the suit only under distract, the complexity of the case, and whether the estimated timeline of trial is likely to exceed 2 days, or any other relevant matter that may be brought to bear. Now, the intent of increasing consistency across the various procedural regimes is also done here. Under this new regime, the notice of appeal is to be filed within 28 days after the registrar's decision. For non-procedural patent disputes, notice of appeal to be filed within 6 weeks of the registrar's opinion. and notice of appeal to be served on registrar and other parties within 7 days of filing, appellant's bundle to be filed within 14 days of the notice of appeal. So this procedure would apply to all disputes relating to Patents Act, Trademarks Act, Registered Designs Act, and the GI Act. Another significant change in the Singapore legislative landscape is the new Copyright Act. This came into force, I think, November 2021. This was enacted with the following key objectives. One, to revamp the old Act into plain English, to make the law more intuitive and more easily understood by the general public. And also to enhance and future-proof Singapore's copyright regime. To also introduce new rights and remedies for creators, such as new moral rights, to encourage the creation of works, and to create new exceptions for users so that the availability of works is not hampered. Okay, now future-proofing. Now these provisions here were intended to prevent profiting of the products or services that stream audiovisual content from unauthorized sources such as set-top boxes and software applications. Manufacturers, commercial dealers, importers, distributors, and service providers of devices and services that facilitate access to such works, which are communicated to the public without the copyright owner's authority, are subject to both civil and criminal liability. New rights and remedies were created for creators as well, moral rights. Before this new Copyright Act came into force, the authors only had a right to prevent false identification in cases where their work is falsely claimed to have been created or performed by someone else. New moral rights provision now confers upon authors the positive right to be identified whenever their works or performances are used in public, subject to certain exceptions. And this right to claim authorship applies also to performers. Now we look at the new exceptions for called the fair and permitted users. Now before the current Act, the copyright regime in Singapore already had an open-ended fair dealing exception. This exception is now called the fair use exception, in line with jurisdictions like the United States. Previously, there were 5 non-exhaustive factors to assess the fairness of the dealing: purpose and character of the dealing, including whether the dealing is of commercial nature or for non-profit educational purposes, the nature of the work or the adaptation, the amount and substantiality of the part taken, and the effect of dealing on the potential market or value of the work, and the possibility of obtaining the work within a reasonable time at an ordinary commercial price. This last factor is now removed, and this is one of the key changes in the assessment of fairness. This removal was so that there is no misconception that users of copyright works may always try to seek a license before relying on the fair use exception. However, the fair use factors are non-exhaustive, so this factor is still relevant and can be still taken into account where it calls for it. Now, in addition to this change in the fair use exception, several permitted use exceptions have been added. So, for example, it is now permissible for schools and students of non-profit educational institutions to use resources from the internet for educational purposes, and also for persons to make copies of works and recordings for the purpose of computational data analysis. Now with that, let's move on to Malaysia. Malaysia has seen a slew of updates to their IP laws in 2022. Malaysia has recently ratified the RCEP agreement, and that entered into force on the 18th of March 2022. In line with this, amendments were made to the core IP legislation, all coming into force on the same date. So this is the amendments to the Patents Act. Key changes are the revision of official fees, accession to the Budapest Treaty, and also that all applications except for PCT applications will now be published in the journal 18 months from the filing of priority date. Early publication is available with payment of fees. A formal third-party observation process is now available, limited to novelty and inventiveness. Now, the deferment of the request for substantive examination is now only available for modified substantive examination, and where the corresponding pattern from the prescribed country has not been granted or is not available. Where the application discloses a sequence, that sequence listings shall be submitted. Annuity payments can now be made for a maximum period of 5 years at a time. Now, in line with the Access to Biological Resources and Benefit Sharing Act, the registrar shall be entitled to disclose information to the National Competent Authority for the purpose of the Patent Office, acting as a checkpoint under that act. And now patents can be the subject of a security interest. Other changes that will come into force later. There will be a new post-grant opposition system, with third parties able to oppose the patent post-grant within a prescribed time. Public inspection of search and examination reports, communications, and citation literature will also be made available. These are the amendments to the Copyright Act in Malaysia, amendments to the Act and the rules. And the key changes are that new offences are now defined, notably for online content and streaming devices, for sharing access to an online location for copyright work without authorization, the manufacture, the import, the sale, the letting for hire of illicit streaming devices, or causing obstruction to search by intentionally destroying such evidence. There's also update of the requirements for the filing of a copyright voluntary notification. This notification system is voluntary and allows copyright holders to provide evidence of ownership as well as evidence of the date of creation of the work. There's an expansion of enforcement powers. Now, this includes the compounding of offences punishable under the Act, the carrying out of test purchases by the IP rights holders in order for the controller to assess whether a punishable offence has been committed, and the requirement of provision of information and evidence from any person if that person has such information. The new amendments to the Copyright Act also provide for seizure by enforcement officers of infringing copies, with or without application from the rights owners. And the licensing body to collect royalties now has been renamed the Collective Management Organization, and relevant guidelines have also been put out. Also, the accession to the Marrakesh Treaty. This is to facilitate access to persons who are blind, visually impaired, or otherwise print disabled. Amendments also came into force for the Geographical Indications Act. The new Act repeals the old GI Act of 2000, and this new Act reflects a comprehensive GI registration system with a wider scope of protection to GI proprietors. Key changes are that all applications will undergo examination. Grounds of refusal are now indicated within the GI Act. And the power to rectify or invalidate a GI now vests with the court instead of the IP office. So GIs can now be cancelled for a number of reasons: breach of grounds of refusal, fraud or misrepresentation, fact that the GI has not been used or it ceased to be protected in the country of origin, or that there's no commercial activity, or that it has become a common name of goods in Malaysia due to non-use of it as a GI. The GI Act also now includes a list of offences: falsely applying registered GIs to goods, importing or selling of goods with falsely applied GIs, submission of false information on the register, or falsely representing a GI as being registered. Now, in line with these substantive changes, the Trademarks Act has also been amended, specifically in relation to collective and certification marks consisting of GIs. The Industrial Designs Act is under review, and this is now at the public consult stage. Now, Philippines has also seen recent changes on its IP landscape. The IP Office of Philippines has extended its PCT filing assistance program. This is a program aimed at encouraging inventors to file under the PCT, and it's extended it to now the 21st of December 2022 under this program, eligible applicants receive fee waivers for the ISR as well as the IPR. The IP office is also launched in March 2022 a new Joanna patent and a new Joanna designs program. Now, these programs are to aid women in micro, small and medium-sized enterprises and aimed at fostering creativity and risk-taking so as to encourage women to participate in the innovation marketplace. And these programs provide some fee waivers for qualified individuals. The IP Office of Philippines has also drafted an initial set of rules on geographic indications. Now, these rules recognize GIs as protectable under Philippine law and provides reciprocal rights and GI protection for other members of the WTO. This is intended to promote local and indigenous products of the Philippines. The draft rules went through the first round of stakeholder consults on 12th of May 2022. And the IP Office has also identified possible GIs, and there's a list that's set out for you. Now, the Executive Order 169 was issued by President Duterte on the 12th of May 2022. This is aimed at strengthening the franchising industry and protecting micro, small and medium-sized enterprises. This order empowers franchise owners by allowing them to register their franchise agreements with the Department of Trade and Industry, so long as they are members in good standing of the franchise associations. Now, EO 169 highlights the rights accorded to a franchise owner, which includes the right to use a trademark or any IP right of the original franchise, so long as this is registered with the IP Office of the Philippines. Now, it's on the side of ADR, the IP Office of Philippines has partnered up with the Office of Alternate Dispute Resolution with the intent of establishing ADR as a key channel for resolving IP cases in the Philippines. This is with the hope that businesses will not be unduly bogged down by litigious court processes. Now, with a view to facilitating the speedier adjudication of IP cases, the 2020 revised rules of procedure were promulgated by the Supreme Court, and it took effect on 16th of November 2020. The changes include the following: the addition of 5 more special commercial courts, increasing the number to 9, the inclusion of a list illustrating what constitutes evidence of actual use, a revision of the order of destruction to distinguish between destruction and disposal, and the addition of the options of recycling or donation and other analogous methods. The acceptance of market surveys as evidence to prove primary significance, distinctiveness, or the status of a mark, and or the likelihood of confusion, and the requirement for training of judges and court personnel. Now, these changes illustrate the court's willingness to adapt to the continuous changes to the business sector and the desire to educate members of the judiciary on IP advocacy. The Philippine government has also increased enforcement efforts against the sale and distribution of counterfeit goods. The past 2 months, raids have yielded counterfeit goods in the amount of 741 million pesos, which is about 19 million Singapore dollars. And the Deputy Director General of the IP Office has also urged local government units to create and implement an anti-counterfeiting and anti-piracy policy, that is to issue ordinances banning the production, sale and transfer of counterfeit goods. The IP Office of Philippines has also launched on the 27th of April this year the IP Learning Awareness Workshop, which is an online IP learning system to promote IP awareness. So this system provides introductory as well as more advanced courses on IP, so trademarks, copyright and patents, all available in both English and Filipino. This is with the goal of integrating IP awareness and education into daily life so as to encourage creativity and innovation. We now move on to the amendments that are happening in Thailand. The significant amendments happening in Thailand this year is the Amended Copyright Act. This is preparatory to accession to the World Intellectual Property Organization Copyright Treaty, the WCT. The Amended Copyright Act has been published on the 24th of February, and it comes into effect on the 23rd of August this year. The amendment pertains to online piracy and technological protection measures, and it aims to address rapid technological change in consumer behavior so as to provide effective protection for copyright works. Now, the key points. 4 definitions of a service provider have been recognized under the Act. The intermediary for data transmission, the data caching service provider, the hosting service provider, and the data locating service provider, which is a search engine. Now, in contrast to previous cumbersome and costly procedures, the Amended Copyright Act provides for private notice and takedown procedures for infringing content. Now, different procedures will apply to different types of service providers, but this new procedure is seen to be beneficial to copyright owners due to the presumption of copyright infringement based on the information provided by the copyright owner. So under this procedure, the allegedly infringing data can be removed quickly and blocked. The onus is on the alleged infringer to show non-infringement. So importantly, the removal or blocking is possible even in cases where the alleged infringer is unknown or located outside Thailand. The Amended Act also introduces safe harbor provisions for service providers. This is the Exemption of Liability. Now, different statutory conditions for exemption of liability are applicable again for the different types of service providers that are recognized under the Act. Now, in general terms, the service provider must have merely provided the services automatically, pursuant to their customer's request, and without any initiation or intervention by the providers themselves. They must also have made available the way to receive notifications of infringement activities. They must also have announced and implemented policies for terminating services for repeat infringers. The Act also looks at a new definition for the term technological protection measures to include any technology that protects the rights of copyright owners and performers, or any technology that is efficiently utilized to control the access to a copyright work or the recording of a performance. Acts which are deemed to be infringing technological protection measures include acts which cause the measures for access control to be ineffective, and the manufacture, sale, distribution, and service of products or equipment having the main purpose of causing the measures to be ineffective. Now, these changes effectively enhance protection of copyright works. Lastly, the term of protection for photographic works has been substantially increased from 50 years from creation to the duration of the life of the author, plus 50 years after the death of the author. Now let's look at the IP laws revision happening in Vietnam. Now, Vietnam is now party to the CPTPP, and the amendments have been made to the IP laws with effect from 1st of November 2019 to comply with Vietnam's commitments. And some of the notable changes are the electronic filing for all applications are now permitted by the IP Office of Vietnam. For patents law, the implementation of a 12-month grace period from the date of disclosure of the invention to filing of priority date for the assessment for both novelty and inventive step. Under trademarks, the acceptance of use by a licensee as being validating use of the registered trademark by the proprietor. Also, that trademark licenses are no longer required to be recorded at the IP office in order to have legal effect. In the area of GIs are now registrable under Vietnam law. Applications may be filed at the Vietnam IP office. For enforcement, provisions have been provided for abuse of process. So this is provisions for the compensation for damages and costs that are caused to individuals or companies due to the abuse of IP protection process. Additional grounds also for determination of damages caused by IP rights infringement are provided. There's also new procedures for the application of a temporary suspension by customs. Under this amendment, the Customs Authority will have an obligation within 30 days from the issuance date of a decision to apply administrative remedies for the handling of counterfeit or pirated goods, to provide to the IPR holder with information on the name and address of the consignor, exporter, consignee or importer, and a description of the goods, the quantity and the country of origin if this is known. There are other CPTPP commitments that have a transitional period, and these will be included in the next revision of Vietnam IP law. And these are that the CPTPP agreement requires members to make available to the public the certain published applications and granted patent information. This is not yet available, and compliance is expected. The CPTPP also requires the data exclusivity for agrochemicals for 10 years from the date of marketing approval. Current Vietnam law provides for a 5-year protection period. The proposed revision will increase this to a 10-year protection period. Some marks also are required under the CPTPP, and this is expected to be part of Vietnam law in future. The proposed revision of IP laws in Vietnam is expected to be enacted sometime in 2022. Additional highlights to these would include, for patents, that secret prior art will be considered during the examination of a novelty of invention, clearer first filing requirements prior to filing of applications abroad. Well, these are the security control provisions. Under the latest draft, security control is proposed to be imposed for inventions which are in technical fields with an impact on national security, inventions created entirely in Vietnam, and which are to be filed by Vietnamese citizens or Vietnamese residents or by organizations established in Vietnam. So such inventions can only be filed abroad if the patent applications have been first filed in Vietnam. Clearer and additional grounds for refusal of patent applications are also expected. The current law provides that a patent application may be refused grant if the invention does not fully satisfy the requirements for grant, it's not the application having the earliest filing or priority date, or that there's more than one patent application satisfying the same conditions for grant and the same priority date, basically a double patenting system situation. So these provisions are considered inadequate. And additional grounds that are proposed include where the amendment to the patent application expands the scope of the subject matters disclosed or changes the nature of the subject matter claimed, or where the amended invention goes beyond the content disclosed in the description, where the invention is not sufficiently disclosed in the description for an ordinary person skilled in the art to implement the invention, or where the patent application concerning gene source or traditional knowledge does not disclose or inexactly discloses the origin of that gene source or traditional knowledge, or if the patent application is filed in contravention to the security control provisions. Clearer and additional grounds for invalidation of granted patents are also expected. The current provisions for invalidation of granted patents only provides that it may be invalidated if the applicant does not have the right to file the application, or if the subject matters fail to satisfy the grant conditions at the time it was granted. So again, the provisions are considered inadequate, and new additional grounds for invalidation are expected, and these are pretty much the same grounds that I've gone through earlier, which are the grounds for refusal of the patents. In the area of trademarks, bad faith is now a new ground for trademark invalidation, and this will be actually the first time it's officially considered a ground for invalidation of a registered trademark. Also now we expect a reduction of citation period for an expired trademark. Under the current law, an earlier expired trademark may be used as a citation against later filed trademarks within 5 years from its expiry date. The proposed revision reduces the citation period from 5 to 3 years. Also for designs, the proposed revision provides for the deferment of publication of design applications in certain circumstances. So thank you very much. I come to the end of my presentation, and I will now stop sharing this. Thank you.
Wow, thank you very much, Reggie. That's a real treasure trove of updates and terrifically specific information on how those ASEAN countries, what's happening in their IP legislation. So thank you so much, and thank you to the country representatives who also you mentioned earlier as providing you with that input. And as also you mentioned, I believe they're standing by ready to take questions, which is exactly where we're moving to now. So I would like to invite anyone from the audience, if you have a question, to please either raise your hand using the reaction button, and you can ask a question to any of the speakers. Or if you feel more comfortable, you can just type it into the chat box and I can read it on your behalf. So any questions, comments, or reactions to what we've just heard from the audience? Okay, I don't see any hands raised at the moment, so I'll just give the audience a little while to think about questions. In the meantime, I know whilst myself and the other speakers were talking, Shoichi had a number of questions, and we thought, well, let's talk about them during the Q&A. So I see Shoichi has kindly raised his hand. So Shoichi, what question would you like to ask?
Yeah, well, I have been sort of following what's happening in ASEAN, among ASEAN countries, and there has been some efforts in the region to have cooperation in terms of patent examination and trademark related area as well. And how do those efforts have gone so far, and any prospects of real cooperation is expected, or eventually, several years ago there was the idea of having ASEAN IP office, like European Patent Office. But is these kinds of cooperation ongoing, or have stalled?
Shoichi, I might take first crack at responding to that. So in terms of interest in establishing an ASEAN IP office, I think there is interest. However, that interest is it's still at the very, very early stages of discussions. As I'm sure everyone in this call would understand, there is a lot of things to organize in terms of setting up a regional facility, not least language considerations, where it might be located, the legislation that would apply to such a facility. So there's a lot of work and consideration that would need to come before the establishment of an ASEAN regional office. So I think perhaps it's more of a long-term project than a short-term project. In response to your question about cooperation in terms of patent examination or trademark examination, there does exist the ASEAN Patent Examination Cooperation, known as ASPEC, which is a regional patent work sharing program amongst 9 ASEAN member states, all except Myanmar. And it's actually been in place, I think, for quite some time, or launched 2009, 2010, I believe. And its objective is really to share the search and examination results between participating officers. So applicants participating in it can get patents in other jurisdictions faster and more efficiently. So it's all about reducing the duplication of search and examination within the region. So thank you for your question.
Yeah, well, thank you very much. Yeah.
You're welcome. Anyone else like to
Yeah, there is one question in the chat box.
Okay. Let's see. It's from Eliza. Thank you for the question, Eliza. How have the efforts like that mentioned in the Philippines towards using ADR to handle IP disputes been progressing? So would perhaps Elio or Reggie like to talk about
Yes,
progression towards ADR?
Yes, thank you, Peter. I will be able to do that with from Singapore, and also I invite my other Singapore colleagues to join in, as well as the other colleagues from around the world that I see on screen. I know that we have that Singapore has tried to use mediation, and that's been included in as part of the trademark opposition process, for example, and that's I believe seeing some traction. In terms of the ADR in trials and all that, I invite maybe Tony or Meryl if you want to comment as well.
Hi, Peter, and thanks, Regina.
Tony.
This is Tony. Well, the Singapore courts have always been strong proponent for mediation. So at every court proceeding, whenever at very early stage, at the pre-trial conferences, the assistant registrar or the senior assistant registrars would try and encourage parties to go for mediation. And in fact, but encourage is a very mild word. They strongly encourage parties to go for mediation, especially if they are of the view that the subject matter of the litigation, and this can cover IP litigation as well, is something that parties can try and resolve. So they would strongly encourage it. They will ask, if you say no, we do not want to go for mediation, next question will be why, and so there's a very strong move towards mediation. As for arbitrations, Singapore is also moving towards that as well. But arbitration as a form of dispute resolution is still not as popular yet, because obviously it requires parties to agree to arbitrate. And sometimes that may not always go down well, especially at the beginning stages of the litigation. Perhaps somewhere along the way, if they feel that they want confidentiality, they might end up going for arbitration. But by and large, if there is litigation on IP matters, the courts would usually encourage parties strongly to go for mediation, and they will try to provide the directions, in terms of if you need exchange of documents prior to mediation, they will try and give those directions so that you can move towards that direction. I'm not sure whether Meryl has anything else to add. Meryl?
Hi everyone, thanks Tony. Hi Regina and everyone. Thank you for this presentation. It was very informative for me personally. I just wanted to add, and I typed this out in the chat so anyone else who's looking at that can have a note of it. In Singapore, IPPI subsidizes actual cash, about $10,000 to $12,000 Sing dollars for parties who volunteer to go into mediation, except that they would have to give permission for IPPI to publish a summary of the facts and the outcome of the mediation and also the parties' names. So it's not a full disclosure of everything, but key facts. So that has proven to be quite useful, and a number of my clients have taken it up. So that's something that's clearly showing how we're pushing ADR for IP disputes.
Thanks, Meryl. Thanks, Tony. I'll add to that discussion. The WIPO also has an officer from the Arbitration and Mediation Center of WIPO located in Singapore. Mm-hmm. And her role is to facilitate ADR within the region, to promote it and to work with member states, IP officers in the provision of ADR services within the IP environment. Okay, let's see a few more chats. Let's see. Thank you, Linda Lecomte, for your comment and helping your US practice. You're welcome. Nazli Korkut, again, you're very welcome. Thanks for the feedback. And to Hauma. Daniel Rees-Mowbray, thank you for the presentations. Thanks for the gastronomic tour. He's off to find a Thai restaurant for lunch. Well, good luck, Daniel. Hope you enjoy it.
Yeah.
Okay, Eliza, interested in serving as an IP mediator? Okay, Hauma poses a question. It is related to Singapore. So in Singapore, is mediation compulsory before initiating litigation in court? If not, what will be the situation in the future? Thanks for the question, Hauma. I'll ask Reggie or perhaps Tony or Meryl to respond to that.
Tony, go ahead.
Thank you, Hauma, for that question. And thank you, Peter and Reg. It's not compulsory at this point in time for parties to go for mediation. But as I explained earlier, it looks like the court is pushing very, very hard for mediations for all forms of litigation, including IP litigation. For example, today, my team just went for a pre-trial conference for a matter before the High Court. And the registrar made it very clear that, mediation is highly, highly, highly encouraged. And he gave directions for certain documents to be disclosed so that mediation can proceed. As you know, it is no point and quite pointless actually going for mediation when certain documents are not disclosed. For example, the claimant may be claiming X amount for damages. And if the defendant doesn't know why you're asking for X amount for damages, obviously that mediation will not go very far. So the registrar will then give directions that certain documents supporting the damages figure be provided. That's one example. And then another example will be, if the plaintiff is making a claim on the basis of certain allegations, and if the defendant is saying no, I refuse to admit the claim that you have made against me. I've got certain defenses, and you put up strong defenses. And then the registrar may also give directions for discovery of certain documents that may support those defenses to be provided to the plaintiff, so that the plaintiff knows, okay, if you say strongly that you deny my claim, and you say that you have got good evidence, and maybe let me have a look at it, so that at the mediation, all these support for the claim and the damages and support for the defense would be before the mediator and before the parties, and so that the mediation can be dealt with more meaningfully. Now, in order to answer Hauma's second question, which is, in future, would mediation be compulsory? It's probably going to move there, and very, very soon. And I think in time to come, it may be compulsory.
Yeah, but it's mediation, right? I mean, it's not arbitration, so it's not binding to the party, whatever the outcome of that mediation is. Is that correct?
Yes, Soichi-san, thank you for that question. Yes, it's not binding. It's still in the hands of the mediator, and the mediators in Singapore are very well trained. They have been very successful in their mediations. I have been to mediations a lot because of the directions from the courts, and the success rate is pretty high, and they go through very good training. It's not just bringing parties together. It's a lot of psychology involved as well. So Soichi-san, as you know, talking to the people, trying to assess, party A and party B, understanding what your needs are, what caused the dispute, where's the middle ground. All this is psychology, actually. So our mediators are very well trained. So although it is not arbitration, the mediator cannot decide on the matter, and both sides do not have to accept what the mediators say, but ultimately it has been successful. We have mediations that lasted, for example, until 4 o'clock in the morning. Starts at 9 in the morning, and it lasts until the next day, 4 o'clock in the morning. And it was it was settled. It was settled. Sometimes when everybody is very tired and want to go back and sleep, and really hungry, and the air conditioning is in turn off, parties would finally see the light of day and settle the matter. Yes.
Okay. Well, thank you very much. I guess, Peter, I guess we have to close the shop because of the limitation of the time. Would you like to take a few more questions, or are we ready to close?
Look, I'll just put a final call. If anyone has a burning question, they can raise their hand now. If not, I see no hands, in which case I'm happy to close the meeting.
I'm sorry to interrupt,
Oh,
Peter.
Meryl, yes.
I'm so sorry. I just wanted to see if there were any other questions, but if everyone doesn't mind to just add on to what Suichi-san and Tony were touching on, in Singapore, one of the biggest sort of changes in our rules of court is that the court may potentially order parties to attempt to resolve disputes by amicable resolution. So they put it in it's always been there, as Tony said, and a duty to sort of get parties to fill up an ADR form and declare whether or not their lawyers have told them about alternative dispute resolution, and then sign off and actually say whether or not they are considering alternative dispute resolution. So in a sense, it is not compulsory, as Tony said, but then parties have this very express obligation to tell the court that they are acknowledging that they are not going to pursue ADR. With our new rules of court that's just come in December last year, there is actually a duty on parties to send letters to try and amicably resolve matters in writing first. So then you must give 14 days, etc. So that's actually entrenched in our rules of court, which probably is in line with what Tony said as well. In the future, there may be some sort of compulsory mediation, but it is something odd because mediation is supposed to be voluntary. I just wanted to add that point. Hopefully it was useful.
Yeah, thank you. I think that adds value to the conversation.
Just to add on to that, there is a big push towards alternative to dispute resolution, particularly mediation, to try and get the parties to resolve it without taking too much of court time. And also our mediators are well trained. And so trademark oppositions, for example, has seen that entrenched as part of its procedure for some time. And that's been actually quite successful, and it's gotten quite good traction.
Thank you, Reggie. Okay, and with that, I will close today's webinar. Thank you again to my fellow speakers, Elio and Regina, for their excellent insights and for their hard work in putting their presentations together. Thank you very much to Shoichi and the team at AIPPI, Judith, and the technical team there for your great assistance for pulling this webinar together. And thank you very much to the audience. I think we've got people from all over the world joining us today. Great to have you along. I hope you got value from it. So wherever you are, I wish you a good afternoon, a good evening, or even a good morning. And thank you for joining us. Thank you.
Yeah, well, thank you very much. Thank you. Bye-bye.